Mr. Justice Tata, my very dear friend, Anshuman Gora, who has taken the trouble of coming all the way from Gauhati, respected senior members of the bar, and my dear young friends. The topic on which I have been asked to speak, understanding the fundamental rights under the Indian Constitution and fundamental duties of citizens and their importance and relevance. Well, originally, the person who was chosen to speak on this topic was Mr. Chowdhury. Perhaps I would not be able to match him on his knowledge and certainly not his experience. Initially, I had thought of delivering a written lecture. Then I thought, this is a young bar. I should speak from my heart. I should speak whatever little bit I have learned over a period of the last 28, 29 years. So you might be wondering, what is this bunch of papers that I am carrying? I am carrying a photocopy of the fundamental rights and the fundamental duties, so that I don't forget the sequence. Otherwise, I am going to speak from whatever little bit I have learned. So please do not expect any flowery language. Please do not expect any famous quotes. I'll speak what comes to my heart and my mind. But before that, before I go on to speak on the topic, I'd like to first congratulate all the stakeholders for having this beautiful High Court building. And I have been very closely associated with the Honorable Chief Justice of India, and in the last 2 days I have had several interactions with him, and in fact the last interaction was at the airport when he was departing. He must have congratulated me and asked me to convey his congratulations to everyone, not less than 5 to 6 times. It's a momentous occasion, and according to him, and you can just imagine, none less than the Chief Justice of India saying that this is probably the best High Court building that he has seen in his life. It is really a momentous occasion for us. And then tomorrow we have our silver jubilee. The other announcement before I proceed to speak on this topic is, I thought that this is a wonderful occasion to make this announcement. I feel very proud to tell you all that I could manage to take a commitment from Honorable Mr. Justice Ujjwal Bhuyan to come to Itanagar very shortly and enlighten us with his thoughts in maybe a similar symposium or a lecture series. And he has assured me that within this week itself, perhaps, he will let me know his convenient date so that we get enough time to organize something proper. I have always, since the day I took over as Advocate General, I have always wanted to do things for this bar which will improve, enhance the process of learning, the process of advocacy. And I was in fact waiting for this High Court building to be inaugurated. Now we have also a beautiful auditorium, so we don't have any problems. As long as I continue, it will be my persistent endeavor to try and bring legal luminaries so that we can improve ourselves in the future. Now, coming to the topic that has been chosen, understanding the fundamental rights. Well, it reminds me of a very important thing that my senior, who also happened to be the former Attorney General of Arunachal Pradesh, when I had barely joined, I was in fact I had not even got my license. I don't know whether all of you know, I have started attending his chamber from the second year of my LLB course. So one of the basic things that he had told me when I started attending his chamber was that we all tend to think that law is, there is this persistent debate going on. What really is law? Is it an art or is it a science? He had taught me one very important thing, that in order to understand our constitution, in order to become an advocate, a reasonably successful advocate, one of the basic things that we need to do is understand the constitutional provisions conceptually. So, as I said at the beginning, I will simply try to explain to you the scheme of the fundamental rights, how it has been conceived of by the constitution makers, and what is it that was sought to be given to the citizens. As all of you must be knowing, the fundamental rights happens to be in part 3 of the Constitution. And part 3 starts with a definition. What is this definition all about? It defines the state. Now, I don't know whether that curiosity has come to your minds. Why is it that the Constitution makers straight away, when they started chapter 3, right at the top, right at the beginning, Article 12, because it speaks about fundamental rights, and Article 12 merely defines a state. So what is the necessity? The necessity is, once I say it, you will probably think that how simple it is. The necessity is that these fundamental rights need to be enforced. As and when a fundamental right enshrined in part 3 of the Constitution gets violated, what do? We file a writ petition. And to file a writ petition, against whom does a writ petition lie? It lies against the state. And that state has been defined in Article 12. Originally, when the Constitution came into existence, there was this huge debate. You will find various judicial pronouncements. Since time is not that long, this is a subject one can go on and on for hours together, but we can't afford to do that. So I'll be as brief and as precise as possible. Now, once the Constitution came into existence, this continuous judicial debate happened, that what really is a state. And the confusion that got created was because of the use of the word other authorities. And as you will find, over a period of time, there are various judicial pronouncements by the Supreme Court, where this term other authorities that finds place in Article 12 has been discussed and explained. Over a period of time, as time moved on, you will recall the famous case of sea telephonies, where even the Board of Control for Cricket was held to be a state within the meaning of Article 12. It has the meaning, if we read it just from the Constitution, it appears to be a very simple sentence, but it has had such complex problems arising out of this that ultimately the Supreme Court had to interpret, reinterpret again and again and again and again. Now, one of the basic things that has been held by the Supreme Court is that when the government exercises deep and pervasive control, it would be a state within the meaning of Article 12. more or less, that is how the law rested for a long time. A little bit here, a little bit there. Then came the famous Z-Televisions BCCI case. And in that, ultimately, the Supreme Court went on to say that even a private body, if it is discharging public functions, that will also come within the purview and meaning of a state within the meaning of Article 12. Now that takes care of the definition of the state. Then we proceed. We find that in Article 13, what it says is, all laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provisions of this part, shall to the extent of such inconsistency be void. Basically, anything inconsistent was held to be void. However, in subclause 3 of Article 13, law has been defined. This is a very important provision, particularly for all of you sitting there. Normally, when we think of law in common parlance, law means, well, the constitution itself, law means a statute, an act, or the rules framed thereunder, or maybe even rules framed under Article 309 of the Constitution. But then, for all of you people from Arunachal, your customary laws, that gets protected under subclause 3 of Article 13. And that is how we in Arunachal have all these customary laws that take care of our judicial problems at the grassroots level, the Devans. So therefore, as I said, this gains a lot of significance for the state of Arunachal. Now, in the scheme of things of the fundamental rights, part 3 of the Constitution, we move on to Article 14, which is the backbone, the spine of our Constitution. What does it say? If you read Article 14, you will find that it is, in South India, perhaps some names are longer than this article. This article finishes off in about 15 to 20 words. But, as I said, the backbone of not only the fundamental rights, the backbone of the entire Constitution itself. It says, the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Just one sentence. Such a beautiful sentence sounds very simple, but this Article 14 has again undergone interpretations over years and years. We are 75 years after independence. It is still being interpreted. That is how beautiful our profession is. We may think that's why the famous legal luminaries always say that the Constitution, unlike a statute, is not a rigid document, it's a dynamic document. It is required to be interpreted with changing times. Therefore, Article 14, I am not going into all that Minerva Mills, Menaka Gandhi, cases after cases after cases. It says that the state will guarantee equal protection of the law and equality before the law. So if we take a plain meaning, it means that no one can be discriminated against. There cannot be any discrimination at all. But the question that arises is it an absolute right? Is it a right that is final, absolute? The answer is a simple no. For the simple reason, had it been an absolute right, there could not have been reservations in this country. Now, the whole concept in Article 14 is couched in The concept of fairness, equity, good conscience, adherence to the principles of natural justice. So, again, going back to whether it's an absolute right, it certainly is a no. Which means now, the state can, if and when certain exigencies arise, the state can differentiate. Now, how can they differentiate? The state can resort to a reasonable classification. When you hear the stalwarts of the bar arguing cases on the equality clauses in the Constitution, you hear a very famous sentence: reasonable classification, having an intelligible differentia, and that intelligible differentia has to have a close nexus with the object that is sought to be achieved. Now the problem starts. What does it mean? There has to be an intelligible differentia. That intelligible differentia again has to have a close and reasonable nexus with the object that is sought to be achieved. So perhaps, like many of the young lawyers sitting there, I was also totally confused. When I joined the practice, I would read this sentence in many judgments, I would not understand. After a long time, I don't know whether all of you know, your former Attorney General Mr. Nigajappa happened to be a very short-tempered man. So you could very rarely walk up to him and ask a question and he would explain that. It never used to be that simple. So one fine day, I gathered enough courage when he was in a slightly better mood. I gathered enough courage to ask him, "Sir, what does it mean?" I had read not less than 10, 15, 20 judgments. I have not been able to understand anything. What is this reasonable classification? What is this intelligible differentia? That has to have a close nexus with the object that is sought to be achieved. He explained it, and since then, I think I have been able to understand. He explained it with an example. My sincere apologies to any bald people sitting here. Naba, please don't mind. Uttam, whatever you are, please don't mind. Because the example involves a bald person. He said, now, let us say there is an advertisement for the post of a lecturer in a college. If in that advertisement, all other qualifications are given, he should be a master's degree holder with 55%, he should be a PhD, eligibility criteria one after the other, and one clause is put that the applicant cannot be a bald man. That is violation of Article 14. Now, try and understand the same example in a different context. Let us say there is an advertisement for selling of homes. The person who is going to get selected will be appointed as a salesman for a company manufacturing homes. Now they put a clause, eligibility condition, that the applicant cannot be a bald man. Now here is a reasonable classification. And there is a very clear intelligible differential which has a direct nexus with the object that is sought to be achieved. Now just imagine Marco going and selling a home. Will anyone buy it? Uttam Bori going and selling a home. What are you trying to sell? Therefore, it becomes a reasonable classification, having an intelligible difference and a direct nexus with the object that is sought to be achieved. The object is to sell a home, and the intelligible differentiator is the person who will sell it. He should imbibe confidence in the buyer that, anyone uses this home will not go bald. But that is how he explained to me. And since that day, I think a little bit of Article 14 I could understand. So, when I started speaking on Article 14, as I said, that it is certainly not an absolute right. The state can make a differentiation, and that differentiation has to be reasonable. Now that takes us to Article 15. Article 15 and 16, if you read it together, you will find that there are a lot of similarities. But at the same time, there are differences as well. When we talk about Article 15, you will find that it is more general in nature. Sub-clauses 1 and 2 are very broad in nature, and thereafter, sub-clause 3 onwards, the constitution makers have made an enabling provision, enabled the state as and when necessary to deviate. Now, sub-clauses 5 speak about reservations in admission to medical colleges, educational institutions, etc. That is how we have reservations in case of admissions that take place in various educational institutions. But it is more or less, if you read it together, you will find that there are a large number of similarities, but there are also very subtle differences. One of the fine differences you will find when you read them together. In Article 15, the constitution makers stop. There cannot be discrimination on grounds of religion, race, caste, sex, place of birth. But it stops at place of birth. But if you look at Article 16, you will find that it also includes place of residence. That's a very fine but interesting distinction between Articles 15 and 16. However, the concept behind this is more or less the same, that there cannot be any discrimination. Now, Article 16 makes it more precise. Article 16 says that there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. It makes it very specific. It makes it specific to public employment. Now again, the interesting thing about Article 16 is, this is again a very important article for my young brothers and sisters sitting here. Again, takes us back to the provisions made for reservation, for scheduled castes and scheduled tribes. But this has again a very interesting judicial history. Originally, when Clause 4 of Article 16 was incorporated in the Constitution, it was made only for the purpose of appointment. What happened was, reservations were being made for appointment. When appointments were being made, there were reservations being made. 15%, 22%, etc. But some states also started making reservations in promotions. When this happened, a lot of cases got filed, and ultimately the matter went up all the way to the Supreme Court. And finally, if I am not mistaken, on the forum, Indra-Swami, if I am not mistaken, was a 9 judge. So, in Indra-Swami, finally, the Supreme Court made it very clear that no, subclause 4 of Article 16 as it stands, it does not confer power for giving reservations in matters of promotion. It confers, the word used is appointment, and the appointment would be only initial appointment. Another important thing was said in Indraswamy. I may not precisely recall the paragraph number, it should be 727 or 728. There, the Supreme Court made another thing very clear, that when you are making reservation, you can also make it by way of an executive instruction. For doing that, the Supreme Court went into all the previous cases and carved out this distinction that whenever the constitution makers wanted, they used the word law made by the parliament or law made by the legislature. Those phrases are not used in subclauses 4 onwards. The language used is this: nothing in this article shall prevent the state from making any provision. So, making any provision and law made by parliament or law made by a legislature, a distinction was carved out, and therefore, in Indraswamy, the constitution said that you can also do it by way of an executive instruction. Now, that position got clarified, but a problem arose for the government. Because it has become, in many states, it has become a regular practice to give the benefit of reservation even in promotions. How do they overcome? There comes the 77th Amendment of the Constitution, where Article 16(4) capital A was added. Here, you will find that subclause 4 and 4A, the language is almost identical. In subclause 4, the word used is in matters of appointment, identically worded when 4A was inserted by the 77th Amendment of the Constitution. They simply changed the word from in matters of appointment as it stands in subclause 4. They changed it to in matters of promotion. Thereafter arose another round of problems. One Mr. A and one Mr. B. At the entry level, Mr. A is at serial number 1, Mr. B is at serial number 2. Mr. B gets promoted to the next higher level. Let's call it X4. Mr. B, by virtue of his reservation, he moves to the next post. Mr. A remains. After 2-3 years, Mr. A, who was originally higher in position, he also reaches the promotional post. Post X, let's call it. Now what happens? How to fix the seniority? Many governments, since Mr. B had got promoted earlier, many governments started giving them seniority above. So A, although higher in merit in the feeder cadre, only because he gets promoted later on, he becomes a junior. Again, another round of litigation started. Different high courts all over the country. Finally, again, the matter reached the Supreme Court. And the Supreme Court again, Constitution bench sits, and they say that no. Since the person A has got higher position in the merit list, it will not be fair because Mr. B has come only because of an additional benefit given by our reservation. So therefore, Mr. A, when he comes to expose, he will regain his seniority, original seniority. That again became a problem for various governments. Ultimately, the parliament made another approach, another amendment. 4A gets amended again. And they add the word in, the precise words used are, in matters of promotion, comma has a very important significance. Please do not, when you are arguing a case or preparing a case on Article 16(4)(a) on issues of reservation, please do not ignore the comma between in matters of promotion, comma, with consequential seniority. So this was basically to overcome the Constitutional Bench judgment on this. And that is where the provision stands as on today. So therefore, now the position is that even if Mr. B is lower in position in the feeder cadre, if he moves to the next higher post, he will continue to enjoy his higher seniority. Then again, you must have also heard this famous phrase that has come about, that is a judicially evolved phrase. The concept of a creamy layer, etc., etc. I am not going into all of that because I am looking at the watch. I have already taken quite a lot of your time. I will try to be as brief as possible. We normally don't very rarely talk about Article 17 and Article 18 because these two articles have almost over a period of time, they have in a way lost their significance. Article 17 talks about abolition of untouchability and Article 18 talks about abolition of title. Those issues have stopped creating problems. The next article gains a lot of significance. This guarantees to each one of us the freedoms. Under Article 19, A gives us the freedom of speech and expression, B gives us freedom of assembly, C gives us freedom of forming associations or unions, D to move freely throughout the country, E to reside and settle anywhere in the country, G to practice any profession or carry on any occupation, trade or business. Now, G, I will first take away come to G because normally when we are interpreting an act, the same word used carries the same meaning. But when it comes to the Constitution, as I said, we have to understand that this is a very dynamic document. So you will find the use of the word trade in another place in the Constitution itself. You will find the word trade being used in Articles 301 to 304 of the Constitution. But the two words do not carry the same and identical meaning. Again, that is a subject. Just to tell you, on the use of the word trade, I had argued a matter for almost 3 days, so I won't go into all that today. We don't have that much time. But what is important to be understood when we are talking about the freedoms that we enjoy is, again, that these freedoms are not absolute freedom. The state, as and when it so desires, from subclauses 2 to subclause 6, the state can bring in reasonable restrictions. If you, just to give you an example, if you make freedom of speech an absolute right, what could be one of the consequences in today's context? One of the direct consequences would be that in social media, it would be flooded with abusive language, all forms of misuse of language. So those things can be controlled by bringing in reasonable restrictions. So again, this freedom, a mature society, a developed society, perhaps there, many of the countries, these restrictions is in the form of insertion in a constitution perhaps would not have been even necessary. But in a diverse and complex country like ours, the constitution makers thought that it is important to give the power to the state to be able to restrict these so that these freedoms are not abused and misused. Now that takes us to, these are so far equality clauses, freedoms that we enjoy. That takes us to the next few articles, Article 20 to 22. Another very vital fundamental right, a very important fundamental right. It talks about life and liberty, which is the most important, I would say, one of the most valuable rights that a citizen in our country enjoys. Had these provisions not been there, just imagine Article 22 being removed. The government would have had the power to, in the name of preventive detention, what used to happen pre-independence era. Anyone, the British government thought that is creating trouble, pick him up, put him behind bars. No safeguards, no safety. That is what was ensured from Article 20 to 22. However, there came a very interesting amendment in between. Article 21 capital A. So one might think that how is it that in the constitutional scheme of things, when Article 20 to 22 speaks about life and liberty, how is it that that got inserted? Because Article 21A, capital A, all of you must be aware, it talks about the right to education. The Supreme Court in 1993 held, I am forgetting the parties' names, held that right to education is a fundamental right. So therefore, the constitution makers, the parliament, thought that we should show due deference to this and we should make it a fundamental right. And pursuant to insertion of Article 21 capital A, again you all must be aware, the Right to Education Act has come into existence and so many benefits pertaining to education, making it a valuable right for young children, has been inserted. Article 22 talks about protection against arrest and detention, etc., the various parameters that need to be followed. Articles 23 to 24, 23 and 24 is focused on right against exploitation, forced labor, child labor, etc., etc. So the Constitution, as a fundamental right, guaranteed that these kinds of exploitations would not be permitted under our Constitution, which were things that were permissible and permitted under the British era. The Constitution makers deemed it appropriate to make it a basic fundamental right and inserted it in Chapter 3 of the Constitution. Then 25 onwards, I am broadly trying to explain the scheme of things. 25 onwards you find the right to freedom of religion. As we all know, India is a secular country. So this right needs to be guaranteed to every citizen, the freedom of religion, and how it is to be preserved has been talked about from Articles 25 to 28. even religious instructions and religious worship, etc., how and it has been prescribed in chapter 3 itself. 29 and 30 pertain to cultural and educational rights, rights of minorities, etc., which again is a very broad-based subject. Then 31 pertains to mostly acquisition of the estates. You are all aware, during the British era, they were not in, of course, in Arunachal, that is, it is still in a way acceptable. But those kings and zamindars used to have hectares and hectares of acquired estates, so it conferred power on the government to acquire those estates. Which brings us to Article 32. But then we must not forget that 32 is not the only rule. It's 226 as well. But 32, the Constitution maker deemed it appropriate to insert it in chapter 3 itself as a fundamental right. That you have a fundamental right to approach the Supreme Court when any of these fundamental rights guaranteed under chapter 3, part 3 are violated. So, the fine distinction is that when you go to the Supreme Court directly, it has to be a specific fundamental right. But in the High Court, where you are filing a writ petition, it may also be any other legal right. So that is the fundamental distinction between Article 32 and 226. And this again has been made a valuable fundamental right itself. On the others, I don't think, because I have already taken a lot of time. Now let me move on to fundamental duties. Again, well, one important thing I forgot to tell you. You can waive all other rights, but you cannot waive a fundamental right. So that has been made clear by the Supreme Court. So that is how important chapter 3 of the Constitution is. So even if you want, you cannot say that you can violate Article 14 against me. You cannot say that you snatch away my freedom. You cannot waive it. That brings us to the fundamental duties. I would not, when it comes to fundamental duties, I would not like to speak too much before an educated audience. I would have spoken, I took more time on fundamental rights because I thought this is an area all of you practice in. So I decided to spend a little more time on fundamental rights. Fundamental duties, talking to an educated audience, I don't think it is even necessary. As we grow in this country, as this country has moved on 75 years, the literacy levels have increased. The education and qualification levels have increased. The numbers have increased. So these are rights, these are duties. I think each one of you already know. The fact that what do the fundamental duties in 51 say? That we should respect the Constitution. All of us already do. It says that we should respect the national flag and the national anthem. All of us already do. Subclause B says we should cherish and follow the noble ideas which inspired our national struggle for freedom. I think most of us do. All of us. To uphold and protect the sovereignty, unity and integrity of India. I need not lecture and educated audience on this. One thing is important. Subclause D says that it shall be the duty to defend the country and render national service when called upon to do so. It's a very important duty. As you all know, in Israel, there is a mandatory 1-year service that every citizen has. If a need really arises in the future, it is something I think the educated people would really come forward, because we know that it is our constitutional duty. It is, I personally feel that when we are talking about Article 15, capital A, it is all of you, when you go back to your respective villages, it is you who should be educating the local village people who are not educated. That these are our fundamental duties. Like for example, Articles 25, 26, etc. They give us the freedom of practicing any religion. In the name of practicing my religion, can I hurt someone else's religion? That is a duty we owe it to ourselves, we owe it to every other citizen in the country. So these are another important provision is the subclause G, which says that we should protect our environment, we should protect our forests, we should protect our lakes, rivers. A land like Arunachal, blessed with so much of greenery, blessed with so much of nature, I think every person from Arunachal Pradesh would understand the importance of protecting them. These are duties. You see, as a society grows, as the society gets educated, more and more educated, these duties get imbibed in us, go into our blood. Just to give you an example, let's say I have someone in my family has his or her birthday today, and I want to celebrate. But my next door neighbor has a child who has his or her board exams next day. It should come from within me that child's preparation is more important than me celebrating my birthday with loud music creating a chaos in the neighborhood. So these are fundamental rights are such, fundamental duties are such duties that every citizen, as he or she gets educated, more literate, would fundamentally understand that these are duties that we owe to every other citizen, these are duties that we owe to the country. So having having tried to explain, I hope I have made some sense to especially the younger boys who are sitting at the back. Coming to the importance and relevance, we need to understand that especially those people who are practicing on the writ side, 226 side in the High Court, the importance of the fundamental rights and the scheme, the concept in which our constitution makers have actually framed chapter 3 is what we should try to understand. If we understand the scheme, it should not be a very difficult thing to understand and appreciate. And to a young guard, at the end, although not connected with the topic that has been assigned to me, to a young guard, my request to all of you is, now we have a beautiful building. And as I said, the Chief Justice of India yesterday said that we have one of the most beautiful buildings, one of the best infrastructure in the country. My request to each one of you would be, please make the most of this infrastructure and please try to live up to the standard of the infrastructure that has been given to us. We need to have the highest level of hard work, dedication in preparing our cases. We have to maintain the highest ethical standards. Till now, we could have perhaps said that क्या जरूरत है ऐसा टूटा फूटा बिल्डिंग में चल रहा अभी तो वो बहाना भी चला गया. Now we have to live up to the standard that has been given to us, and we have to maintain the highest possible level of. You have seen how the Honorable Chief Justice addressed at 10:30 in the morning. He has been given a lot of good feedback, but it is also time for all of us to get together and improve ourselves in the profession so that this Itanagar bench really excels. With that, I conclude my speech. Thank you very much.
Article 51A is non-justiciable. Do you think it is time that we started having, a small amendment there? That it is time that citizens started getting a little, some enforceability so that there is some accountability from citizens. That was my question to you.
So far as 51A is concerned, it was a very conscious decision of the framers of the Constitution to make it non-enforceable. And there is a logic, and the logic was perhaps, I did not explain in so many words when I was delivering my speech. The logic is that when the Constitution was framed, this was almost 75 years back. Now, when the Constitution was framed, the idea was that as we come out of the era of colonialism and as we have our own governance over a period of time with proper education, the consciousness and awareness of the people will improve. And that is what I was saying when I was delivering my speech. That I don't need to talk about fundamental duties to an educated audience. The logic is that with time people will have it in their blood that if necessary, as and when the time comes, I am ready to do my fundamental duty. So that, and so far as any amendment to make it enforceable is concerned, ultimately it has to be wisdom of the parliament. Thank you.